Well, good evening, everybody. Welcome to another great episode of the Van Buren Variety Show. I'm Bob Van Buren, your host. Thank you for joining us. Hope you've had all a great week so far. I have. In fact, what I'm going to tell you what I've done will lead us into tonight's topic. Recently, I'm ashamed to say, I have never had, up till now, never had a last will and testament done. That's very, very risky because unfortunately, hopefully not, but when someone dies without a will, here comes the family and the cousins and the friends and everybody that wants a piece of the pie. And didn't think my family would do that. I really don't think so. But now that I've got a will signed, it's ready to go. There's no question who I'm leaving what to whom. So I guess I would suggest to you watching this, if you haven't already made a will out, if you've got things that you want to go to see certain people or a charity even, I would strongly suggest you do that, because even right now I know someone that's going through that, where a person did not leave a will and now there is severe conflict within the family. So just telling you this as a public service, just think about your family and friends and who you would want to be your heirs or heir. In addition to that, I got power of attorney. For those of you that don't know what that is, let's just say that you're in a terrible car wreck or you have a disease where you can't think clearly, your mental capacities are not there, or just somewhere you're out of town and there's a big financial decision, you're not there to make that decision. Pretty much power of attorney means that you've assigned someone else on your behalf to make those medical decisions or financial decisions. I didn't have that before until about a month ago. So I have that now. I've assigned two people actually to be my power of attorney. So if one can't do it or unable to do it, I have the backup. So just take it from me. It's you'll have peace of mind if you do that. So if you haven't made your will out and you don't have power of attorney on yourself, or you haven't assigned anybody, please go see a licensed attorney today, because it will save not just you some grief, but your family as well. So there's my PSA for this evening. So for whatever it's worth. So anyway, I sleep better knowing that's been taken care of, in case we never know day to day how much time we have on this earth. So I sleep a lot better now. Speaking of legal, another thing that legal things people do is, of course, when you meet somebody, that special someone, you fall in love, this is the person you want to spend the rest of your life with, and you get married. And everyone, when they get married, they always think about it as someone who's going to be their life partner for the rest of their life. For example, when you put the ring on the other's finger, like this little statue here, you think, this is it. This is where we're going to be. We're going to be married forever. We're going to raise kids, grandkids, have a great life together, take some vacations. But now all marriages on this earth will eventually end. How they end is pretty much kind of iffy sometimes. When we get married, most of us think that our marriages on this earth will end something like this, either through your own death or your spouse's death. Like the old vow goes, till death do us part. And that's how many marriages do end. But not all marriages end in something like that. Many times, more often than not, marriages end in a place that looks similar to this. Yes, a court of law where the spouses now face off. There's probably a dispute over property. Obviously, child support if there's a child there, child custody. So, and that brings us up to our topic for tonight. There are two ways, legal ways, that we're going to talk about tonight. One is a divorce, and one is an annulment. Now, we've probably heard the terms, but maybe not everybody's familiar with what's the difference between a divorce and an annulment, and more importantly, what are the specifications or conditions for an annulment to exist, which will bring me to my next guest now, and I'll bring him on now. Ladies and gentlemen, I'd like to introduce you to Tim Mendolia. He's with M&P Law Office in Aledo, Texas. Tim, welcome to the Van Buren Variety Show.
Thanks for having me, Bob.
Okay, well, let's just kind of get right into this. Tonight's topic is both divorces and annulments. So tell us kind of what is the difference between, now they're both marriage ending, obviously,
Correct.
but what's the difference between someone who's getting a divorce and an annulment? What are the difference?
Well, an annulment basically says that the marriage never existed to begin with, versus a divorce, which is the legal dissolution of a marriage relationship.
I see. So they're both marriage ending, but pretty much annulment means it's like stricken from the record, like it never existed.
Correct. It basically comes from a nullity. In other words, it says that the divorce never existed, and there's certain factors that have to. There's only a certain things within Texas state law that allows you to nullify a divorce rather than go through nullify a marriage rather than go through a divorce, which actually terminates the marriage relationship.
I see. So now we've heard some legal terms. There is two parties to a divorce and or an annulment. One is called the petitioner, and one is called the respondent. Well, what's the difference? Who is who in that?
Petitioner is the one that files it to get an annulment, to get a divorce. There has to be a lawsuit. You have to file in either depending on jurisdiction in certain counties, you have to file in either a county court or a district court. And so you file the lawsuit. The person that files the lawsuit is the petitioner. Okay. The person on the other side, the non-filing party, would then be called the respondent.
I see. Now we've heard the term legal separation. It's been thrown around, but is there a such thing as legal separation? And if it is, what is that?
There is legal separation in certain states, but Texas law doesn't recognize legal separation. Basically, how Texas law handles it is once a divorce is filed, if you want things to go a certain way, we have to take care of property. Usually more on the children's side of it. We need, temporary spousal support, temporary child support. To put that in place, you just go to the court and petition the court for temporary orders, and temporary orders list or survive during the pendency of the divorce until the divorce is ultimately final and there's a final divorce decree. So rather than calling it a legal separation, there has to, number one, be a divorce filed. And then number two, then you have to ask for temporary orders to be put in place. And that keeps status quo and things like that in place while the divorce is going on, during the pendency of the divorce.
I see. So if a husband and wife decide, hey, this ain't working out, I don't love you anymore, but husband goes over here, wife goes over here, they don't file, they're still legally married then at that point, correct?
Yes. And that's a very important point because, community property law in the state of Texas basically says that anything acquired during the marriage, other than by gift, devise, or descent, basically inheritance or a gift, anything acquired during the marriage is community property. And by acquired, that is either debt or asset. So if parties just go their separate ways, but there's not a divorce in place, there's not temporary orders in place, and one party goes out and incurs a huge debt or buys a large asset, that is considered community property, even though they're no longer living together or separated. That would be considered within the eyes of the law as community property.
I see. So if say husband and wife is, they're living separately, but maybe one spouse wins the lottery, the multi-million-dollar lottery, their spouse has just as much right to that money as they do. Is that correct?
Yeah, and that's the worst. That's the worst case scenario. But yes, that's probably the best example you could give. Is that they're completely separated, and then you've got one party that wins the lottery, $10 million, whatever that number is. Well, legally per Texas law, the spouse, even though they're separated, not together, the other spouse is entitled to 50% of it.
Wow. I can kind of relate. I worked at a bank many, many years ago, and we had this happen so many times. I'm sure you as an attorney have heard it. husband and wife have a joint checking account, and there's quite a bit of money in there. Okay, they get into a fight. They decide it's over. Wife goes to the bank, writes that check, closes the account, and husband says, "Hey, half that money was mine." But we're like, she had as much right to that account as you did because her name was on it. No divorce, and then all we can tell them is you fight it out in court. So
Right.
I'm sure you like that. It's community property. Would that be a good example too?
Yeah, I mean, obviously, if one spouse sweeps a bank account, the other spouse has a reimbursement claim for their 50% of that, but that's all it is at that point is a reimbursement claim. If that spouse squanders that money, does something with that money, going to be awful hard to recover it. So yes, that is a potential problem in all divorces. Joint accounts, you need, a lot of times our advice is if the client is in fear of the other spouse cleaning out an account, it's going to be contentious, then we usually advise go take half of that money and open another account. So therefore you're not taking any of their money because you're leaving half of it, but you take your half and safeguard it, safeguard it in another account so that you have some protection.
I see. Well, let me stop right here. Ladies and gentlemen, I meant to say this at the very start. We do have a disclaimer on this. I apologize for not saying this at the very first, but want to make it clear, this episode is not intended to give you personal legal advice, okay? It is only to inform what the law defines as a divorce and what it says about an annulment. So if you or someone you know will be going through a divorce or an annulment, my best advice is contact your own licensed attorney who can better serve your individual needs. So take this as just an informational, this is what the law says.
Yeah, and we're going over generalities and definitions and things like that. Obviously, we're not giving direct advice. Any and all divorce cases, family law cases are very fact specific, and so advice is going to be tailored. With any licensed attorney, is going to be tailored towards those facts. And so, unless your facts fit exactly what we have just talked about, then you need to talk to somebody, get that full advice, and let it be tailored to your facts.
Absolutely. Okay, well, we kind of touched on kind of what a divorce is and what it's not, what an annulment is. Let's go over just a few things. As I said earlier, if you get an annulment, which means it never happened, there are certain conditions that have to exist. So let me kind of put some towards you, and you can kind of tell our audience kind of what it is. Some of them are kind of self-explanatory, but let's just kind of go through it. One reason to get a couple can get an annulment, in other words, written off. It says marriage of a person under 18 without parental consent. Does that mean maybe the spouse lied about his or her age, or like how would that take place?
Yeah, I mean that could be the circumstance. I mean, bottom line, if one spouse didn't realize that the other was underage, and therefore consent wasn't granted by parents, then potentially that marriage could be annulled.
Okay. Then you have this one too. This one's kind of strange, but I mean it's valid. But I'm going to tell you why I think it's strange. It says being under the influence of alcohol or narcotics. I mean, how would they not know if that person was under alcohol or narcotics without them, staggering around? That's how I figured it. But
I would liken that to basically we call it the Vegas divorce, right? Two people go to Vegas, they get they get drunk. It's a really good Friends episode. My wife would enjoy that, but as Friends episode where they go to Vegas, get drunk, get married. That divorce can be annulled because they were under the influence of alcohol.
I see. Now here's another one that's now on a serious note. You talked about fraud. An annulment. I mean, a marriage can be annulled due to fraud. What would be some examples of fraud?
Fraud. I mean, somebody misrepresented something, about themselves, about their background. Fraud is basically a misrepresentation that somebody relies upon and acts upon. So if they somehow, misrepresented who they were, what their background is, whatever it may be, and that the other spouse relied upon that when they agreed to be married, then potentially that could be a reason to annul the marriage.
For example, just kind of throwing this out there, maybe husband says he's a multimillionaire, it's got 2 mansions, that's where they're going to live when they get married, then come to find out he's pretty much poor.
Exactly. I think that's a very good example.
Okay. And then this one's really it's very serious. I mean, it's all serious, I understand, but we've heard the term shotgun wedding. You might have other examples, but another reason for an annulment is duress or force. Kind of go into that a little bit more, expand on that.
Yeah, I mean, that would be the typical shotgun wedding, right? You're going to marry my daughter. She got pregnant. You're going to marry her, whatever that may be. I don't know if that fits today's time as much as it may have back in the day, but, duress could be basically you're somehow threatened by some illegal action that causes you to not be able to exercise your normal judgment. So, however that may happen to fall into a fact situation to where, you're getting married, but you're not really wanting to get married, that would be a duress situation.
I see. I've also heard it, and I've heard other examples where it comes out that after the marriage, that one of the spouses kind of threatened the other spouse. In other words, this spouse knew something, kind of some dirt or some blackmail material on the other person's family, threatened to expose that if they didn't get married. Obviously, that would be duress for sure.
Yes, definitely. And there may be somebody that's trying to, get married to get into, for financial reasons or something like that. So they find something to blackmail the party into getting married. There could be any type of factual situation that would fit that, where you're just being coerced or duressed into being married.
Mm-hmm. Yeah, the duress. Yeah, I want to make sure I got the duress means the person's actually feeling forced to get married against their will.
Again, it's some type of threat of illegal action that causes you not to be able to exercise your normal judgment.
I see. Okay. Then here's another one that's interesting that I didn't know about till we talked. You mentioned another reason for an annulment is concealed divorce, and it says within 30 days of new marriage. So you have to wait 30 days once you're divorced. Is that true?
Yes, you're supposed to by law. And so if they conceal that, that they got divorced 2 days ago and, get married, then, 2 days later, that's going to be within that time frame. That doesn't, and again, all of these factors that we're pointing out, these are all set out in the Texas Family Code. It doesn't mean the divorce is automatically null and void. It means that gives you reason to file for annulment and have the court grant it. So, I mean, if you get legally married, but these facts exist, well, the divorce is the marriage is going to continue on as a marriage, a legal marriage, unless one of the parties brings this up, files for an annulment and brings forth these reasons set out in the family code as to why this marriage should be annulled.
I see. And then here's another one I might want to expand on, mental incapacity.
Right. I mean, that would, I guess, Ann Nicole Smith, that yes. Whole case,
yes,
where, she got married to that elderly, very, very much older multimillionaire. And I think there was a dispute over whether he had the capacity to marry at the time that he got married to her. So you could have that type of situation. I mean, it's basically if one of the parties is not capable of mentally making that decision, whether it could be injury, it could be disease, whatever it may be, then they have to have consent of their guardian, or, if it's a disabled person, disabled adult, say, 25-year-old kid that's, potentially got autism or something like that, to where he's actually has his parents or brothers, says somebody is a guardian of him, well, then that guardian would have to consent, unless, because he would be mentally incapable of making that determination.
Now we're talking mental incapacity at the time of the marriage. I'm just throwing this out there. Let's say that husband and wife get married, they're perfectly fine. A couple of weeks later, say husband gets into a bad car wreck and it does something to his brain. He's now mental incapacitated, but as far as annulment goes, that means prior to the marriage. Would that be a correct statement?
Yeah, it would have to be at the time of the marriage. So anything that would happen that would cause incapacity afterwards, obviously, I mean, that wouldn't fit for an annulment. I mean, otherwise you could have, any type of injury like that. You could have somebody going to try to annul, or, elderly person, potentially becomes incapacitated as they get older with dementia, Alzheimer's or something like that. And the other spouse then goes to annul. Well, that, they've been married for 25, 30, 40, whatever years. That really wouldn't fit what the law set out to do.
Is there a certain time limit when a person can get an annulment? I know if most time they're very married for a very short time, but is there a time limit at 1 year, 2 years, 3 years when you can get a marriage annulled? Is there a specific time limit or no?
There's usually, I believe, and I'd have to be honest with you, I don't know off the top of my head exactly. I believe there's a 2-year statute of limitations, but that goes to the time that you find out about the reason. So there's a 2-year statute of limitations that normally runs from the time of the marriage, but that can be extended by what they call the discovery rule. The discovery rule says, well, I didn't discover it until a year after that she had lied or he had lied, committed fraud. So then the 2 years would run from the time of discovery of those facts.
Okay. And that's the reason I ask these questions. I want to make sure I know my audience. You can't just get an annulment on the fly. Right. I mean, there has to be a specific reason. It's not like divorce where you just, I guess, fall out of love or just a different situation. Annulment. We talked about duress. Let's kind of talk about what duress is not. Let's just say maybe a couple has planned a very expensive wedding, and the last minute, maybe wife decides, oh, I'd rather not get married on that day. I'd rather get married on a different day. But in other words, she's going to say the duress was because she felt like she had to get married because of the expense. That's not duress, correct? Or is it?
Yeah, I wouldn't think that would fit the definition. Again, the definition is more towards, you're being threatened by some illegal action, whatever it may be. Well, just because you changed the wedding day or something like that. I don't think that would fit into the definition. I mean, they could file for an annulment, but then it's got to, go through the court system, and, a judge or a jury would ultimately determine was there duress, and they would listen to all the facts and make that determination.
Right. And like even, unfortunately, some people take care of sick parents, but, my theory on that is, well, you can postpone the wedding date. You don't have to get married. You're not being forced to get married.
Correct.
So yeah, I think a court would probably throw that out if that's someone tried to file like that.
I would believe so. Yes.
Yeah. Okay. Now now we're going to get both in divorce and annulment. Not all the time will parties agree on things. Right. So we talked about the petitioner. That's the person who actually files for the divorce, whether it's the husband or the wife.
Correct.
Okay. Say that he or she files for the divorce, and the spouse says, you know what? I'm not signing that paperwork. I'm not going to do it. No, I'm not going to do it. And so what's the next step for the petitioner if they can't get that done?
Well, it's important to note that Texas, there are some states that require some type of fault to be alleged to get a divorce. Texas is considered a no-fault divorce state. That means that if one party wants to get a divorce, they're going to get a divorce, and all they have to allege is, they call it insupportability. And there's basically a specific paragraph that's set out in the family code. The marriage has become insupportable due to discord or conflict between the personalities. It destroys the legitimate ends of the marriage relationship and prevents any reasonable expectation of reconciliation. A bunch of legal mumbo jumbo, basically, that says, We just don't want to be married anymore. And that's enough to allege in a divorce petition in the state of Texas to ultimately get your divorce. Now, more to your point of what, if the other side just doesn't want to cooperate, bottom line, if they're not going to, there's a very simple process to get an agreed divorce done. Both parties agree, one can file, you can get a waiver of citation signed. They ultimately agree on an agreed divorce decree. You let the statutory 60 days run, go in front of a judge, one party's there, they prove it up, and the divorce is finalized. A divorce can be very, very simple under those circumstances. If the other side, under your scenario, doesn't agree, doesn't react, then you've got to basically start a legal process. You've got to have the petition legally served on them by either a constable or someone that's registered with the court to serve citations. Once they are served, they have a specific amount of time. Basically, you can say 20 days, but it could be up to 26 days because it's the Monday following the expiration of 20 days. So if you were served on a Tuesday and 20 days ends up ending on another Tuesday, or you're served on I guess it'd be a Wednesday, 20 days ends up on a Tuesday, well, it rolls till the next Monday. So it could be a little bit extra, but normally it's basically 20 days you have to answer. And if you don't answer, then potentially default could be taken. But then you have the 60-day waiting period. So that person would not have to answer for 60 days, according to family law. And then on 61st day, if they haven't answered, the other side could go to the court, take default, and just present to the judge they've been served. They were properly served. They failed to respond. The 60 days had run. Obviously, the answer date has run because that's going to be well within 60 days. And then they can, get a divorce decree signed by the judge.
Okay. Yeah, because we run into many situations because, in a divorce situation, the spouses are just at each other's throat. Let's talk about the person who's being served, which would be the respondent. How does the person who's doing the serving locate that person? Do they go to their job? They go home? They tail them in town? Was there any kind of process where they try to locate the person to hand them the paper, so to speak?
Sure. Any number of ways. I mean, generally, if I'm working with the petitioner, we have a private service that we use, but you could also use the constable. But you pay the constable, you pay the private service. They set out, generally it requires on the citation, which is what they're actually served along with the petition, an address. You give, whether it's their home address, could be a work address. You generally put on there an address that or you believe is going to be someplace that they can be served.
I see.
So it could be work. A lot of times we try to avoid that because of the embarrassment, whatever, and try to get them to served at home. Send the process server. Okay. They generally get home at 6 o'clock, go sit out in front of the house, wait till, 6 o'clock arrives. They pull up, the process server goes and serves them, things like that. So it's a little more private, but, then you run into the potential of somebody dodging service.
I've heard about that. Yeah.
Yeah. I mean, if they do that, the process server, if they make 3 attempts, at different times, they go early in the morning at the house. Well, they didn't leave for work that day. They go, late at night. They didn't come home because they might've figured out somebody's sitting out front. So they just drove by, or, I went to work and I couldn't get past the front door. As long as they make 3 attempts, then you can petition the court for some type of substituted service other than personal service, which could be posting it on their home address door, or, there's different ways to do substituted service, and then they'll effectuate service that way. And that's by court order. You have to petition the court to allow for some type of other service than which would normally be hand delivery, and then the court allows that, so that whatever it is, if it's posting on the door, certified mail, whatever it is, then the that effectuates service on that person.
I see. Well, let's just say, for example, we talked about how the spouse refuses to sign, so they had to be served.
Mhm.
Okay, let's just say they've now been served, but I think you touched it a little bit. Let's kind of go over it. But they've been served now, but now they're still going to say, you know what? I'm not signing that paperwork. I'm not going to do it. So what happens when they still refuse to sign the paperwork and acknowledge it?
Yeah, if they don't file an answer, then again, once you've been served and you haven't answered, the court kind of treats that like, you're totally ignoring the process. And therefore, once the 60 days is run, that without any notice whatsoever to the party, the non-responding party, the petitioner can show up at court and get a default. So, it's very inadvisable not to answer in any lawsuit, family law or otherwise, not to answer when you've been served with papers, because you open yourself up to default judgment. And what I mean by default is they show up, they present the judge a divorce decree, they go through to do a prove up. All you have to do is testify to what you put in the petition. We were married on this day, we were divorced on this day, the marriage is insupportable. We propose that the community estate be divided this way. And they present the order as to how they want to do it. And generally, when they're taking a default, they get everything they want, right? They're not going to not put something in there. They're going to say, well, everything goes to me. All the community property is now mine. And if that other party is not there, the judge signs that becomes a final order.
Wow. So not advisable to pull a no-show. I mean,
exactly.
I can't imagine why anybody would pull a no-show, especially an annulment even. Well, let's just say, you talked about an answer earlier. Okay, spouse, we're talking about the spouse who refuses to sign paperwork, not going to do it, but they send an answer back to the court, whether a written statement or maybe disputing the details of the marriage, break apart, whatever it'll be. Let's just say they've sent an answer now to the court, but didn't sign the paper. At that point, what happens then? The court?
Well, they've answered. So they're now legally before the court. But if they continue to not cooperate, and not want to get an agreement, then ultimately the petitioner will set a hearing date, a final hearing date, and then they show up at court. And again, even if they've answered, if they've been given proper notice of the hearing, and there's different timelines, for different types of hearings, etc. But if they've been given the proper notice of the hearing and they don't show, then again, default can be taken. So, non-cooperation by a party ultimately is going to result in the filing party getting what they want. So, if you do dispute, you better show up, you better answer, you better show up at hearings, or ultimately you're going to, everything's going to be granted on the other side.
And that kind of brings up to my next question, Tim. Let's just say one party states that he or she cannot afford an attorney. Will the court appoint one? Or how does that work in civil matters, or do they?
Civil matters, they generally don't appoint counsel. There are there's West Texas Legal Services. There are some services that provide either sliding scale or pro bono representation in civil cases. But as a matter of law, there's not court-appointed attorneys in civil cases. There can be in certain instances. The best example is some type of contempt. Let's say someone in a family law situation, it would be someone is not paying child support. Well, if the non-support paying person is served with a motion for contempt and it alleges criminal contempt, meaning we're going to put you in jail for not paying child support, which is allowed in the state of Texas. Yep. If it's criminal contempt, then the court, because it's criminal, because there's a potential for jail time, the court can and will appoint counsel for them. And, and understand, when appointed counsel is used by the court, that's county tax funds that's being expended to help somebody in the courtroom. It happens all the time in criminal cases,
Yep.
but very rarely, only in those criminal contempt situations in family civil cases.
I see. But I can't even imagine, a party that's going to, like, for example, get an annulment or divorce, they answer and don't show up to court. I mean, if it was me, if I said I couldn't afford a lawyer and I knew that my soon-to-be spouse was going to tell a bunch of lies about me, I'd borrow the money. I would find a way to get a lawyer up there.
Well, and I mean, potentially, Bob, you can represent yourself. Definitely not. I mean, not advisable, especially if the other party doesn't. The other party has an attorney, because when you represent yourself, you're charged with knowledge of the law. So if you go in representing yourself, and the other side has an attorney, and the attorney on the other side, you try to get evidence in. Well, I got this picture, whatever. Here, judge, I want you to see this picture. Objection, judge. The proper predicate hasn't been laid for that picture, for that to be admitted into evidence, unless that pro se, that's the person representing themselves. That's what they call them, and that's that pro se litigant knows how to respond to that objection and knows how to properly lay the predicate to have evidence introduced, then that evidence is not going to come in. Well, judge, I've got this picture. I need to show it to you. And the judge is like, she's made an objection. This other side's made an objection. Do you have a response? Well, it's a picture. Okay. Objection sustained. I'm not going to allow that in. So, if you show up and there's an attorney on the other side, you're not going to fare well.
Sure.
Because of that, you're charged with knowledge of the law. Now, I will tell you this, courts don't always strictly follow that, and there is some leeway, and it can be very frustrating as an attorney on one side with a pro se litigant on the other, that the court allows them leeway, because the law says they're not allowed any leeway whatsoever. They're charged with knowledge of the law, just like they were a lawyer.
I see. Now, let's just say that during this time, one or both of the spouses gets a lawyer. Is there like a contract that they have to sign? I've heard about this thing called contract for legal services. What is that, and how does that work?
Yeah, I mean, if you're going to a law office, you have a consult, whatever, you decide, okay, this is who I want to hire, then you generally, 99% of lawyers enter into a contract with that person, and that's for protection on both sides. Obviously, the lawyer wants to be paid for services, and it's going to spell out in there whether there's a retainer, what the hourly fees are, how fees are charged, etc. And it also outlines what the representation is, the scope of the representation to protect the client as well. So it really protects both parties to have a contract between the lawyer and their client.
I see. Okay. Let's just say now everything's done. The divorce or the annulment. Well, let's stay on annulment for right now. What happens when the annulment is granted? And what I mean by that are there records that have to be changed at that point? I mean, at that point when they say that the marriage is null and void, what normally happens with the court? Sure.
To finalize the annulment, there's going to be a decree of annulment. Final decree of annulment, and that decree basically states in there by court order, it is ordered that this marriage is annulled, meaning it never existed. It sets it out, and that document then becomes proof to be used later on if a party has, let's say, the party on the other side changed her name or did whatever. The order is going to say that they must go and change back to their maiden name or prior name. They can't use the married name any longer, etc. So it's just a defining deal. I think an annulment, most importantly, it will establish that there was never community property, because if the divorce didn't happen, then there was never any community property, so that the other side can't come back and claim, well, wait a minute, we were married, and your example of winning the lottery, had a person getting the annulment won the lottery, then got an annulment, earlier we were talking about, well, that would be community property. Well, it would no longer be community property because the marriage was annulled. It never existed. Therefore, that person, that won the lottery would be able to keep all those proceeds.
Sure. Now, you touched on something that actually was my next question, Tim. We're talking about community property. This kind of going more into divorce now more than annulment. Let me just give you a hypothetical. Let's just say husband and wife, they've been married for a few years, and they decide they want to purchase a home. And they have a mortgage, however long that may be, 20, 30 years, whatever the time it is. But within a few years after that, the couple splits up and they both agree to a divorce. There's no dispute there.
Right.
The husband, in this case, in this hypothetical, remains in the house. He still wants to live there. Wife moves on. She doesn't want the house. She wants to go on with her life. They're divorced now. But the problem is husband and wife's name is still on the mortgage. Wife wants her name off the mortgage because she's not going to be coming back. They're not going to be reconciling. So I guess my question is, what actions could she take in that hypothetical?
Well, first of all, in your hypothetical, the house was acquired during their marriage, correct?
Yes.
Okay. So it would be considered community property, which would then be divided within the divorce. And, it happens in probably, I would say 80% of our divorces that we do, this type of situation. There's different options. If the party that's retaining the home can and is willing to go and refinance in their own name, then that's one way of doing it. And that clears the other side off of the deed and everything else. There's deeds that'll be done within that, but we can take the non-house retaining party off of the mortgage through a refinance. That doesn't happen the majority of the time because they bought the house with joint income, and refinancing, a lot of times they're just unable to do that with one income, using one income. So there's been developed through years of community property law in Texas. There's ways to do that. We deed the non-retaining party deeds the property to the guy, in this case, the husband. So the wife would deed the property to the husband. The husband then would turn around and do what they call a deed in the assumption back to the wife. The deed in the assumption puts the wife basically like a mortgage holder. So husband would take the house, husband would take responsibility for the note.
Okay.
But if husband failed to pay on the note, wife could use the deed in the assumption to actually foreclose on the house to save her credit because her name is still on the note. So to save her credit, she could go and foreclose on the house.
Against the husband.
Against the husband, right? Because he's not paying on the house.
That's true.
So, you've got to have a protection for that. And the good thing about the way this works is mortgage companies will accept these cross deeds that are done in a divorce along with the divorce decree. And therefore, let's say we did that, husband moves along, he's paying on the mortgage, everything's fine. Wife then wants to go purchase a home on her own. That mortgage, even though her name is on it, will not be used against her by another mortgage company in applying for a new mortgage because the deeds were properly done, and she's in the assumption position on the other mortgage. So there's protection there. And what it boils down to is the mortgage company, there's kind of a conflict in Texas law. The mortgage company family code doesn't force the mortgage company to release somebody. They've got two people on a note. They don't want it. They're not going to give that up.
They don't care. Yeah,
they don't care. The banks are going to keep two people on that note. So, that's how we work around that situation. It works fine because it's not used against the other party. The only time you have a problem is when the husband in your scenario doesn't make payments on the house, falls behind on the house, and that starts affecting wife's credit, and then we've had that numerous times where they come to us, and at that point you have to basically you become a mortgage company and foreclose on the home.
Wow. Lots of red tape I can see, right?
Yeah. Yeah.
Well, we talked about community property, but this is something that we've seen couples fight over. Maybe they didn't have children, but they did acquire pets. And we'll just give another hypothetical. Let's say during the marriage, they got a dog and they've had it for a few years. Both husband and wife wants the dog. They both can't have it, obviously. So how does a court make a determine who gets the pet, the dog in this case?
It's just a factual, if it goes all the way to court that they can't resolve who's going to take the dog, and you're in the courthouse. I mean, generally, I'll just tell you, that's going to, everybody's paying legal fees on both sides. Ultimately, they're going to agree. Somebody's going to agree to who's going to take the dog, most likely, because they're not going to be paying two lawyers to be in a courtroom fighting over who's going to take possession of a dog. But under that scenario, I mean, it just becomes a fact issue because the dog is personal property acquired during the marriage. So it's community property. They both own 50% of that dog, according to community property law. So without an agreement, a court or a judge or a jury has got to determine what party is going to take the dog.
Okay. Interesting. Now, this does happen. I've heard about this happening before. And, I have my personal opinion on it, but let me get your take on it too. Okay. Husband and wife, they're splitting up. They're getting an annulment. They're getting a divorce. Okay. Court case has been, or the court date, should I say, has already been set. Between that time and between the court date, should the spouses avoid each other? And what I mean by that is, try to avoid going to the same social event. No phone calls, no emails, no contact. Would that be an advisable thing to do?
It really depends on the personalities of the parties. Obviously, if there's children involved in this divorce, parents are going to have to cooperate, right? You're going to have, most likely, you're going to have either temporary orders or if they're not temporary orders, then the parents are agreeable as to how they're going to see the child, pick them up, drop them off. There's going to be communication there. But again, depends on the personalities. I mean, in those situations when there's very contentious issues between the parties, they actually have different forms of communication that the parents can sign up for, to where they only communicate through this portal, so that, and the reason they do that is the communications are completely recorded so everybody can see them. Mm-hmm. And that's the same way in dealing with text or dealing in email. That way what's being said, so that if it does become contentious, well, we can go back and we have a record of it. But generally speaking, as far as avoiding places, again, depends on the circumstances, right? If there's been some type of family violence alleged in a deal, and potentially there, you could move as far as getting a protective order. But if not, I mean, if it's you just got a hot head on one side or the other, then then it would be our recommendation, hey, stay away from them. If you go into the same restaurant, just leave. Or exit, or, don't go to a party if they're going to be there. So it really just depends on the personalities of the people. If there's, how contentious is it? If there's somebody with a volatile personality, and then you kind of advise and you look at it and be careful along those lines.
Sure. And I was even thinking about, entrapment. Maybe one spouse is leading another spouse to come somewhere, I say isolated, or just maybe they're setting them up for something, to maybe, derail the hearing even. Like, okay, look what they did. If I'm such a bad person, why are they talking to me? Why are they dating me? Et cetera. So
well, and we warn our clients all the time. Usually on the female side, we're warning them to be careful. Don't put yourself in a situation. If he has a tendency to get violent, then don't be alone with him, because we don't want you injured during this. We don't want harm to come to you. On the other side, the males have to be careful of, like you're saying, there's the potential that, girl calls, says, hey, come pick up some stuff, or, I got some stuff over here, some mail, come over to the house and get it. He shows up, next thing you know, she's calling the police and saying he hit me.
Mm-hmm. Exactly.
And there's no witness there. There's nothing else. Mm-hmm. She goes in the bathroom, next thing you know, she's got a bruise on her eye, and he's saying, I didn't touch her. Well, they're generally, woman's crying, got a bruise on her eye, they're taking that guy to jail.
Period. He's going to jail. There's a mark on what I call the victim in this case. Yeah.
Yeah. So you got to, we always talk about those things with our clients and just say, you've got to be wise to those situations. You've got to be careful of the situation you're putting yourself in. Basically, you've got to always, whether you're talking on the phone, you got to understand that potentially you're being recorded. And if you're going somewhere and you think that there's any potential for that kind of situation, then bring somebody with you, have a witness there, so that, not a child, don't involve children, but bring a friend, bring somebody so that you have another witness.
That's excellent advice. Yeah. Especially if it's a bitter separation, there's no reason to see that. So I would advise my audience, don't ever put yourself in that situation. It's just best to wait for the court case, mouth shut until the meantime, until it's on. So
sure.
So, what do you see in your practice? As far as, a generality, why do most marriages fail? And I'll tell you what I think they do. I think it's based on not so much unfaithfulness, but lies. Someone maybe during the engagement that lied, could be about their, financial situation, their living arrangements, and then lies carry on into the marriage. So do you see something? What do you see as a top reason, I say, that marriages they split up?
I think, in my experience, top reason are finances. Struggling financially puts stress on the marriage. But then from there, going down from there, I think lying, I think that kind of goes into being unfaithful. But lying. I will say this: adultery is a fault that can be alleged in divorce cases in the state of Texas.
Oh, really?
I tell people all the time, they come in, I think he's cheating on me, this, that, or the other. It can be alleged as a fault, but unfortunately, with the way our society has grown and gotten so used to infidelity, it's not a bright line, move the 50% just because the other side, committed adultery. It used to be, when I started out, 25 plus years ago, adultery was a big deal. But nowadays it's not a needle mover. It's not, you're not going to automatically, because you prove adultery, go from 50% to 60%. I get more because he cheated on me, or she cheated on me. It's just not that big of a deal anymore. And I think that speaks to society and where we are. And that's probably for a whole nother show for you to discuss. But it's just kind of where we are nowadays.
Well, I actually have someone in live chat that commented on something that you said earlier, talking about how spouses, maybe if it's contentious, to stay away from each other till the divorce. And you mentioned getting someone to record it or have one record. Here's the comment. Gene Hudson says, I thought they had to tell you that they were recording you. Is that a correct statement?
No, recordings are admissible as long as admissible in court, as long as one person to the conversation knows that it's being recorded.
As long as one person absolutely knows. Okay.
So if you know it's being recorded, the other side doesn't have to know for it to be admissible.
But if a husband and wife are, like, say, talking somewhere in public, maybe on a bench somewhere, and a third party comes up behind them or somewhere and records their conversation, neither husband nor wife knows they're being recorded, then that would be illegal, correct?
Correct.
If it's a third party recording whatever, and neither spouse knows it's being recorded.
It's got to be one person to the conversation.
To the conversation. Okay, so I want to make
Yes.
sure that was okay. Hope that answered your question, Gene. I didn't know the answer to that either. So, okay, let me read you a letter that I received a few years ago. You can give your personal opinion, legal, whatever. Now, this marriage did not succeed. So this was written from the husband's point of view. I'll just read just kind of a little bit of it. They'd only been married a few weeks. He said he came home to find their apartment empty. He called her, and she was at her parents' home. He went there, and he found out that her father was ill. But she had known before the wedding that he was ill, but had kept it secret from the husband. She had been visiting her parents' home each day when they got married and decided to move back in. He tried to get her to leave, come back, but she said she didn't love him anymore. And so he just left. Didn't trust her anymore, obviously. And according to this letter, for 6 months, they had no contact. She just wanted to move back into her parents' home and take care of her elderly parent. Just your opinion on that.
Well, it potentially could have fall into an annulment situation because there was potential fraud in entering into the marriage, that she knew her father was sick. She knew that she was ultimately going to be living and taking care of father, but didn't let her husband know prior to the marriage. So it potentially could fall into annulment. But I mean, as far as one party leaving the other, and those types of situations happen all the time, unfortunately.
Yeah, really. And just kind of touch on it. We didn't really touch on it a whole lot, but the annulments are really bad enough, and divorce is bad enough. But when you get children involved, I'm sure that is times 100. Those kind of cases, I'm sure.
Yeah, obviously. We always try to advise at our law firm. We try to advise that, yes, you may have contention against your spouse, but we've always got to understand, and it's written in the family code. When we're dealing with children, it's always what's in the best interest of the children, and that's it's not defined in the family code. It's used in the family code, and in case law defines best interest and has multiple factors to make that determination. But that's how the courts make determinations regarding children. So we always try to advise our parents, look, try to keep the children as far away from conversations, from what's going on in the divorce as you possibly can. You want to make it, obviously, parents are no longer going to be living together, so it's not going to be seamless, but you want to make it as easy on them as you can. Bringing children into the fight, unfortunately, we see it all the time.
Yeah,
and children are getting, pulled on from either end. You get into parent alienation, and, where one parent is alienating the other parent by just continually berating them. That causes damage to the kid. It causes, it's horrible. And
I'm
so
sure
we always advise against any of that, and try to guide our clients to, I just try to keep that always in the back of your head. What are we, what's the children seeing? What are they, what are they hearing? Try to keep them away from that as much as possible.
Sure. That's good advice. And we would hear so many times where you can use the analogy, it's a tug of war. And I've seen so many kids ripped apart. Sure. It's bad enough that the husband and wife or mother, father don't get along, but don't turn a child against the other one. But unfortunately we see that, and I just think that's so ill-advised.
I completely agree. And, there's many cases where, you have a parent just, to the point of where the other child doesn't even want to see the other parent because of things they've been told. We've dealt with cases where a child has to be sent away to be deprogrammed, to basically learn again that other parent is not the horrible person, animal, whatever it is that they've been made out to be by, father, mother, whatever. So, yeah, it's horrible. It's scarring on the children. It causes, all kinds of therapy and everything else that is just simply not needed. People can get divorced and they can,
Sure.
they can live and get along, and you may not like that person, but you deal with them because there's a child. And we tell people all the time, kids may be 6 years old when you're divorced, but you're going to be dealing with that other, your ex-spouse, even beyond the 12 more years before that child's 18, because
Right.
that child's going to get married. That child's going
Mm-hmm.
to have grandchildren. So if you can figure out how to, be at least amicable, so that, it's not always contentious when everybody's around, then, graduations and weddings and,
Sure.
birthdays and things like that can still be enjoyable for the
Yeah.
child and not have all that contention. So, yeah, I mean, we're attorneys and counselors at law. So, I mean, I kind of take that as we're counseling our clients through that, and hopefully, they're taking heed to what we're trying to tell them, from our years of experience in dealing
Sure.
with.
Well, Tim, boy, this has been an interesting show. I didn't know a lot of things about the law. What it spells out about divorce and annulments and marriage breaking apart. So I appreciate you being with us, Tim. It's been a very learning experience. I appreciate your time.
Well, and I appreciate you having me on, and I'd love to come back and talk more about other legal issues if you have the need, in the future. But I would like to just shout out that we're located in Alito, Texas.
Mm-hmm.
We practice in Parker County, Dallas, or Parker, Tarrant, Dallas, all the surrounding Metroplex counties. It's M&P Law Office, and we're located right on Interstate 20, in between Alito and Willow Park. And love to help anybody through any situation that they might have.
Absolutely. And ladies and gentlemen, again, that's M&P Law Office in Alito, Texas. And so this is Tim Mendolia, my guest. And really, again, we probably will have you back to answer any kind of more kind of what the law says segments.
Sure. Love to be back, Bobby.
Okay. Well, Tim, have a great day. And again, welcome. Thank you for being on the Van Buren Variety Show.
Yes, sir. Thank you.
And ladies and gentlemen, that is going to do it for this episode. I'm glad you joined us. Hope you learned a lot. Remember, every week I have an individual guest talking about a different subject. Could be a hobby, could be a profession. It might be a how-to segment. Even got some musicians lined up. So make sure you subscribe, and you'll catch everything. We're here once a week. And so I'd love to have you join us for the next episode. Again, this is Bob Van Buren for the Van Buren Variety Show. Hope you have a great evening, everybody. Good night.